Hi guys, welcome to Sri Rajamatangi Academy. We are now in chapter number 11 of your institute material, CA institute material, but that is not actually the chapter number 11. Chapter number 11 of the Companies Act is different from chapter number 11 of your institute material. We have already told you this in the previous points on the other chapters. Companies incorporated outside India. That is your chapter number 11 of institute material. But that is the actual chapter, which is called chapter number 22 of the Companies Act 2013. Companies incorporated outside India. Very simple chapter. I have summarized this in one page like a one-liner, like how I gave it for the other chapters. I hope it should have been very useful for you to study and glance it. Exactly the same thing. I have brought it under one single page coverage. It should be very helpful for you to cover. Now, what is this particular chapter? If you remember, guys, we were talking about camel companies. You remember? We were talking about camel companies in the previous chapter. When we were talking about this camel, we told there are so many external companies, correct? If you see on control, access to capital, membership, liability, all that we have covered in the previous. But when we are talking about this external, we said so many companies are there. One of them is foreign company. If you remember, foreign company, government company, Nidhi company, producer company, public financial institution, like that. We have told so many companies, including the Section 8 company. So what is this foreign company? In simple words, the company that is incorporated outside India. That is a normal point which you will understand. But what is more crucial for you to know about this chapter is, only when you study about chapter number, basics of chapter number 1 to 10, you will be able to cover this. What is chapter number 1 to 10 I am talking about? That is your Companies Act chapter numbers. Like from chapter number 1 is preliminary, 2 incorporation of the company in incidental matters thereto, 3 prospectus and allotment of securities, 4 share capital debentures, 5 deposits, 6 charges, 7th is management and administration, 8th is dividend, 9th is accounts of companies, 10th is auditor and auditors. So only after that they brought this particular chapter as chapter number 11 of your institute material. But as per the Companies Act, it is not chapter number 11, it is chapter number 22. Now, without knowing the first 10 chapters or the basics of it, you will not be able to cover this. So only I said this chapter is very simple, because that 10 chapters itself, we made it very simple. So this is going to be even more simple, but only the perspective of the form numbers or the basic requirements is going to be there. Now, if you see this particular sheet, I have brought in the section numbers, section names, and the content to remember. Section numbers, are you going to remember? You are going to remember only section numbers, which I am going to say it is important. How you will know it is important? See the green color aspect that I have given, which I have colored in a green color like this. Now, for this alone, you can remember the section numbers. For others, if you remember, great. If you don't know, don't write the section numbers, so that it will create a bad impression out of it. Now, section numbers, section names, and content to remember. And for this to know, we said we already the previous 10 chapters you should have covered. Okay. It has got no connection with the other laws. This is going to be the only one thing. Section 2, subsection 42. If you see the first one, I hope it is visible. Section 2, subsection 42. When you're talking about definition of foreign company, where you will study about definition of foreign company, chapter number 1. Chapter, I'm only taking you through the quick way, then we will color the material. Chapter number 1, preliminary definitions, and then how and in an electronic mode, this foreign company can also work. There are some 5 points. If you know this, this particular section is over. This electronic mode, I wanted you to mark it important or write it along with me. Then and there, electronic mode, definitely they will ask you a question in any format or in any exam, irrespective of whether in whatever attempt, this is going to be important. Next, application of the act to foreign company. That means they will talk about the applicability of sections. What section numbers and all will be there. How easily you can remember what are the sections that is there. I have colored here. 380, 381, 382, 383, 84, 385, 386, 392, and 393. These are the applicability of the sections directly to foreign company. You can write this also. I have colored it. So these are the sections applicability. Sir, should I remember all these sections? No, you don't need to remember too much on this. And there are some requirements that will be there. The deadlines will be there, or a percentage will be there. That if you remember, they will ask you in a case-based question or a direct question and answer. This is 379. 380 basic documents that are to be delivered to the registrar by the foreign company. What I have told you, whatever it is, you will give the documents to the registrar so that ROC is like comfortable and within the deadline. There are some 5 heads which are very crucial. And then form FC1. I already told you the previous chapters. What are the forms that you will use? FC is foreign company. Foreign company 1, foreign company 2, 3, like that. There will be some 2, 3 forms only. That's all, not more than that. So what are the 5 heads? You should make it very strong because I told you this green color is important for your exam. So that 5 heads you should be strong as a theory, or if they ask in a case-based question, you should be thorough. Accounts of the foreign companies. Accounts of the companies means which chapter you will cover? Chapter number 9. Accounts of companies like books of accounts, financial statements, consolidated financial statements, all that basic and all we would have studied. That chapter number 9 connection. Chapter number 9 of Companies Act. Always remember this. Plus, there are some other acts like FEMA and all, and some other section numbers of this particular other acts is Foreign Exchange Management Act 1999. For this, there is a form called Form FC3, and there are some documents that you need to submit to the ROC, which is a very normal basic process. Okay, these two are very big. 380, 381 is big in the sense important. It is not big, it is important. So only we say it's going to be big from the perspective of the exam. Display of the name. You will display it outside the office, your letterheads, bills, invoices, and also there will be some 3 points, which will not be a big question, but it will be a very simple point. Service on the foreign company. Here itself, I will complete. Either in post you will try to do, or in electronic mode you will try to do. I already told electronic mode is a frequently asked question. Electronic mode means how they call it as electronic mode. Separately, they will ask as a question. Because manual mode, nobody bothers. But since the company is incorporated outside India and the place of business in India, they will connect with the electronic mode. If you remember, foreign registers of your management and administration, chapter number 7. So you would have studied about this foreign registers. So indirectly, what and all will be covered there, and section 128 will be covered there. 128 also, in that also foreign registers, that and all you would have studied in chapter number 9. So go and connect there. See the connection that I am giving. Very importantly, one, I am talking about chapter number 7, foreign registers. Another, I am talking about books of accounts, section 128 of chapter number 9, accounts of companies. Go and study that. This is nothing. And only one single line answer, either through post or through electronic mode. Where you will study about electronic mode, you will study in section 2, subsection 42 here. Here you will study about EC. What is EC? Electronic mode, which I have already told you. Section 384 about your debentures, annual returns, registration of charges, books of accounts and other inspection, all the other chapter references. Debenture will come in 4, annual return will come in 7, registration of charges will come in 6, books of accounts will come in 9, and inspection will come in chapter number 14. See what I am writing here. I will write here itself and finish this chapter. Debenture will talk about 4, annual returns 7, registration of charges 6, books of accounts 9, and inspection, inquiry, investigation, not in your purview, but in CA final or self-paced module, it will come in chapter number 14. I should not write this in numbers. I should write this in Roman letters. But for your easy reference, I am telling you in number. Okay. So this also is nothing. This also is nothing. Display of the name also is very simple. Anyways, I will color it quickly in the institute material. Service on the foreign company, either post or electronic mode. So that also is nothing. Okay. Then what are the other chapter references? I told you, if you remember all these chapter numbers, you will remember perfect. Fees for registration of documents, nothing, because all the fees, what they will charge for registration, you will not see the act, you will see the rules. Act is 2013, rules is 2014. For that, separate rules is called, which is called Registration of Foreign Companies Rules 2014. In that, there will be some small 1 or 2 points. I'll color it from the study material and show you. There will be nothing beyond this. Interpretation. Again, nothing, because they will interpret the definition of foreign company, which you already covered in section 2, subsection 42. So this also is important. So section 2, subsection 42 is important. 380 is important. 381 is important. See, why I am saying important? Because in other sections also it will connect. You will get that in the question. It's a very small chapter, guys. You should not take too much time for this. Hardly you will have to spend half an hour after my class. Otherwise, you will sit and study for more than that also. But after my class completion, because I would have given all the connections here and there, it should be very, very, very basic. Okay. So inspection also is not a big thing. See what I have told for interpretation. Connection with the definition of foreign company. If you know foreign company definition as per section 2, subsection 42, what is going to be the big deal? Nothing. Next, dating of prospectus and particulars to be contained therein. Prospectus means where you will study chapter number 3 of Companies Act, prospectus and allotment of securities. You would have already studied about section 26 and all. It should be dated, it should be signed, it should be with an expert statement. All that you make it thorough. You go there immediately, go and study, which I have already covered enormously well. That if you cover, it is going to be applicable for what? Foreign company as well. So next, 388, 387 and 388 is interconnected because it is PAS. 387 is what? Dating of prospectus, particulars to be contained. Go directly to section 26. You will get it. You don't need to sit in middle with this chapter. You can revise that chapter again once, because now you know as per the foreign company means, yes, you can still try to do it based on the requirements of the prospectus mentioned in section 26 for foreign company as well. So you don't need to sit and study here. You can glance and go back there. So this is not again very big question because you will connect there. Provision as the experts' consent and allotment. When you are talking about the experts' consent and allotment, you will again connect with prospectus and allotment of securities. Again, we studied there fully. I am not going to take it fully. Why I am not taking it fully? Because already it is there. You would have taken the notes also. I am giving emphasis on that. So in 2 places that will come. Next, registration of prospectus. Very important. There will be some 5 documents that is to be annexed. When you register the prospectus, what is going to be that? Okay, registration. Now 387, 388, 389 is connected, but 389 registration for the foreign company prospectus, 5 documents should be attached. So that is going to be important. Offer of IDR, offer of Indian depository receipt. So they are talking about the IDR, which again we connected that in chapter number 3. But central government involvement, SEBI ICDR regulations as to what is ICDR. Issue of Capital and Disclosure Requirements Regulation 2009. The 2009's perspective only they have told here, because after that there are also 2015, 2019 and all, plus chapter number 15. What is chapter number 15 is your mergers and acquisitions, similar connection, compromise, arrangement and amalgamation. So what you studied in your accounts will be connected here for your Indian depository receipt, which we already connected. So 387, 388, 389, 390, 391, all this will be indirectly connected with your chapter number 3. Prospectus and allotment of securities. Chapter number 3. 387 is dating of prospectus, which you will connect with section 26. 388 is expert's consent. That means before application of prospectus, if he has withdrawn, if he has not nominated, all that stories and all, you will glance. Quickly go there and glance. Registration of prospectus is important here because they are asking this question. Now you can ask me, sir, how are you telling that they are asking this question? The hint is 2 hints. One is the book back question. If you go and cover the book back questions of the institute material, whatever I told will be majorly covered. The second hint is RTP and MTP of your particular attempt. RTP and MTP if you, of your particular attempt, if you glance, you will get some questions. You can see the section number and glance that with along with whatever I am telling, it is important. You can easily complete this chapter. So 2 things, book back questions with the MCQ, which I will show you. Second, it is going to be RTP and MTP of your particular attempt. Hardly 1 or 2 questions they would have asked. That is going to be nothing for you to get it. So you can easily cover it. Are we clear? So what and all is going to be there? Till 390 we have covered. 391 is application of 34 to 36 and chapter number 20. What is this 34 to 36? 34, 35, 36 is civil liability and criminal liability. So they will talk about if you do anything mischievous or anything against the provisions, are you liable from the civil side and criminal side? Yes. Go back to prospectus and allotment of securities. We would have already covered with the diagram. Civil liability means what you will do, how you can escape. Criminal liability means what will be there, how will you escape. Go to chapter number 3 because there is nothing to cover again. We already covered, so there is going to be nothing on this. Punishment for contravention, yes, they are asking it in a book back question. Generally, I'll say punishment don't study, but this alone for this chapter you study because they ask this in book back question. There is a chance. Just glance. Hardly it will be some 4 or 5 amounts. It should be very easy. To whom the penalty punishment will be? For the foreign company and for the officer in default. When we say officer in default, OID, officer in default. So that will be there. So this is a very simple one. I will show you this. It's in a book back question also. Company's failure to comply with the provisions not to affect the validity of contract. Some provisions they have not complied. Okay. Does that mean that the contract itself is not valid? You cannot say it is void. It is still valid. You will still continue with that particular provisions and all. Since because you have not complied with the provisions of chapter, it will not stop the contract. That has got no connection with this. So the answer is yes. This also you can glance, not a very big important point. So the answer is with this 2, you should not get confused. Complying with the provision is separate. Validity of contract is separate. Validity of contract will be always valid, even if there is no non-compliance, even if there is no complaints of such provisions in this particular chapter. Okay. Now, rule number till now, this section number 393, we have told all these sections that is important. Rule number 12 of companies, registration of foreign companies, rules 2014 is there. There, what action you will take if you do improper use or improper description of the foreign company, they would have told. That also is there in your institute material last part. That I will cover it in the institute material. Very simple again. Last is, there is no section, there is no rule. Exemption under this chapter. Who will give exemption under any chapter? Central government by notification in the official gazette will do. So central government. Normally in any particular chapter, The last section, if you see charges and all, the last section will be central government can notify anything as that as per the official notification in the Gazette, official Gazette. That's what is there in this particular chapter. This is the basics. Now, what and all I have told important, we will cover. What and all is not there in important, when I show you itself, you will understand. So, third chapter, you should be thorough when you compare to foreign company, because it will cover so many sections, 26, 34, 35, 36, IDR, expert statement, all this. So, you should be double thorough. When you cover this chapter, go to chapter number 3. Work over. Then, in some places, accounts of companies will they cover, books of accounts. So chapter number 9, they will cover. So that also you will make it stronger. Are we clear? Some regulations like SEBI, ICDR, you should know. FEMA Act, you should remember. Forms FC1 and FC3 only is there. That you should try to remember. Central government can exempt something. Rules is there for the registration of foreign companies. So registration is important. Documents is important. Accounts is important. Remaining at all you can glance. And section 384 talks about all the other chapter number references, where I have already told debenture is 4, annual return is 7, which is your section 92 to 94. Debenture is section 71. You can write this and you can also see the material. So debenture 71, material that I am going to show you. Annual return is 92 to 94. So chapter number 7. Registration of charges is your chapter number 6. Books of accounts is chapter number 9. Inspection is chapter number 14. Okay. So fees is as per the rules. So all this, if you cover, it is great. Now, are you getting a picture that this chapter is nothing? Yes. So shall we go to the institute material and cover this? Yes. Now we are into chapter number 11 of the institute material. But as per this, you should cover chapter number 22. See here, they have told here very simply, it is going to be chapter number what? Chapter number 22. So we will cover this. Chapter number 22. 379 to 393A. This and all we should try to cover based on what? Based on the foreign company, that this and all. Yes. Shall we go one after another? Yes, now foreign company, section 2, subsection 42. We'll color the keywords and we'll make it very strong. Foreign company means what? Foreign company means a company which is incorporated. Any company or body corporate. Body corporate means it includes foreign company. You would have studied this in chapter number 1. Go and study what is body corporate. We have already covered this in chapter number 1. Go and study what is body corporate. We would have told it includes foreign company as well, but not the cooperative society. Now, the keyword here, it is incorporated outside India, but place of business in India. So the point is very, very simple here. This certain points only I'll give more importance, because other things I have already told how it is going to be. Incorporated outside India. That means not in India, but then if it is outside India, why will I bother about this? But the place of business in India. It can be by itself or through agent or physically or electronic. This electronic only we told what it is important. You remember? So only that one-liners basic definitions I covered. Now you know electronic mode is important. And why I am giving this important and? Because both should be satisfied. And conducts any business activity in India. Just place of business alone is not the point. Business activity also should be in India. That's all. This definition is going to be very crucial. It is under conditional or conditional? Under condition. So glance this, you should understand. So incorporated outside India, place of business in India, business activity in India. 3 points you should remember. If you remember this, you know what you are talking about. Okay. So there will be some examples which you know it is going to be important. Foreign subsidiary, yes, that also will be covered under. So that is what they are talking about. Booking agents. Will it be covered? Yes, it will be covered, because they are saying by itself or through agent. Foreign subsidy, yes. So these illustrations and examples you can glance based on the definition. Now, according to the company's registration of foreign companies rules, electronic mode means what? I told electronic mode is important. Yes. Electronic mode means electronic base where the main server, whether main server is installed in India or not. It can be or it need not be, but not limited to. That means there will be some points to be shown. I am not bothered about where the main server is. I am bothered about the 5 points. What are that 5 points, which we have already showed in the one-liner? 5 points. Business to business and business to consumer transactions, data interchange, and other supply. So B2C is business to consumer, electronic data interchange, data alone is interchanging, and other digital supply transaction. This and all is electronic. This they will ask in the exam. Next, offer to accept deposits or inviting deposits or accepting deposits or subscription in securities in India or from citizens. That means I am not bothered from whether it is only within India. From the citizens of India also they can be, where they can also be outside India. Chapter number 5 coverage. I told you no deposits. So what is a deposit? What is a eligible deposit? All that if you study, you will understand this point. So the point is very simple. I don't need to be whether it is within India or what. Here when we are talking about the word securities, you will go to chapter number 3, definition, securities definition, as per SCRA, Securities Contract Regulation Act. Do you remember? Go and study that. Now I told you how important this connection is. So securities also you can subscribe in India or from the citizens of India. You can do, that is also electronic mode. Are we clear? Each and every point I wanted you to study because I told it's important. Financial settlements, SEMA, Foreign Exchange Management Act 1999, web-based marketing. That means you are not there. Place of business and activity is happening. No, I don't bother where the server is. Web-based marketing, advisory services, transactional services, database services and products, supply chain, Amazon, that this, whatever it is, anything that is relating, all these are electronic mode. 3 points are very strong. Did you cover up this? Yes. Any other online services like telemarketing, now what all, it is all electronic only. Nobody is coming in person in doing marketing. Telecommuting, telemedicine also. They subscribe the prescription in through the app itself. Education, information research, everything that you do, it is all what? Electronic means, electronic mode. Based on this, they will ask you case-based question. So be very careful and strong. Read it 4 or 5 times. Any other related data communication services, that also has to be included. It can be email, it can be mobile, it can be social media, it can be through cloud, it can be through voice transmission, data transmission, or any other. Everything will be covered. Are we clear? So when we say electronic based securities, explanation, when we are saying for the purpose of this class, electronic based offering of securities, subscription thereof listing is as per IFSC. Mostly this will be exempted. Mostly this will be exempted because you cannot try to deal it with an INR sometimes on this. IFSC, International Financial Services Center, which is set up as per SEZ. You would have studied this in tax. The place where you don't need to ensure the tax has to be paid, that is as per a special economic zone. You have an act called SEZ Act 2005 that will not be construed as an electronic mode. They will ask you this in MCQ. IFSC, can you consider that as an electronic mode? The answer is no, because that will come under what act? Special economic zone. So no SEZ. So I am giving an into here also. I am giving an into here also. It is not covered under this. Previous points and all is tick. This alone is into. Are we clear? Yes. Now I wanted you to strongly remember this electronic mode. Based on this only, major questions will be asked. There will be one example which they have told, place of business activity incorporated outside India, but conducting business activity means yes, it should be considered as a foreign company, which I already told you. Glance this example. Applicability of the act to the foreign companies. What did I tell you? I already told you this. 380 to 386 and 390 to 392 to 393 will be applicable. You remember this? Now I'll go to the one-liner. See this. I have colored this. When I colored this, I told all this will be applicable. That sections which I colored in the yellow color, that only is going to be applicable. That's what is given here also. So applicability of section plus requirement. What is the requirement? Not less than 50% of the paid up share capital, whether equity or preference or partly paid or partly equity, partly preference of a foreign company incorporated outside India. It can be held by anyone, citizens or companies or any other body corporate incorporated in India, whether single or in aggregate, whether individually 50% he is holding or together, I don't bother. But if it is adding up and it is more than 50%, this chapter 22 will be applicable. So the keyword is what? 50% or more. 50% or more. If you have it, then requirement of this particular foreign company section chapter number 22 will be applicable. So what percentage? 50% or more. That's all is the whole section. So what I will write here, I told you one percentage is there. What is this percentage? 50%. That's all. 50% exceeding means chapter 22 will be applicable. That is what they have given. Now an example, 26 plus 25 is more than 50, so it will be applicable. That's all. Very simple. Very, very, very simple. Okay. I don't bother about this remaining holding because they are saying incorporated in Dubai, place of business in India means any company, because these people are all subsidiary. Okay, so these people are indirectly connected with this because the MR company LLC is going to be a foreign company because incorporated in Dubai, place of business in India. That's all. Close. Both conditions should be satisfied. No, activities also. Yes, that's all. Documents, etc., to be delivered to registrar. Again, I told you important. What and all are the documents? Leave the documents. They will ask you majorly on these documents. Within how many days the foreign company has to deliver this to the registrar for registration? The answer is 30 days. Number games. They will play this with you in the MCQ. Every foreign company shall within 30 days of the establishment of place of business in India inform ROC that, sir, we have done a registry, we have done a foreign company registration. We have done all these details and all. So as per section 380, we will give you all the details. And we are doing it within 30 days of the establishment of place of business. I have incorporated it differently before. I don't bother. But if I have established the place of business in India, within 30 days, you will have to give all the details. What all the details? All the details means what? See, I have colored here. It should be helpful. This colored PDF also I am going to upload after you so that along with the G drive access, you will be able to get it. Certified copy of the charter, statute, MOA, AOA, all this you should give. Okay. And more importantly, if it is not in English language, give it in the English language as well. Okay, English language. I am rounding this off, so it should be easy. Full address of the registered office, principal office. List of all the directors and secretary. Now, guys, I am not sitting and explaining to you like a kid because already you know about this in your chapter number 7. Correct? Chapter number 9 also. So I am not sitting and explaining too much because you know directors and secretary only will take care of it. So I presume that you are already thorough with those chapters. And all the other particulars like personal name, surname, this and all is basic details. farmer name, father's name, mother's name, spouse name, date of birth, all this and all, you can glance. Residential address, nationality. If the present nationality is not the nationality of the origin, then what is your original passport number, date of issue, country of issue, who gave this, what's your PAN, what is your occupation, do you have a DIN if you are a director in Indian company? DIN means what? Director identification number, SIN, corporate identity number, any other directorship, membership number if you are a company secretary, and email ID. All these basic details. Apart from that, you should also give ROC, name and address of one or more persons resident in India who is accepting the notices and documents be served by the company. Their address also, full address of the office, when you are opening, when you are closing, what and all you are trying to do, what are all the declarations that the directors has to give, any other information. This, whatever I have colored, I will save this and give it to you. You can do a newspaper reading. If you do a newspaper reading, you will get all the basic details of an application form that you will submit it with the ROC. So all this we should cover and give it to ROC within how many days? That only is the point. 30 days of the establishment. Remaining and all you itself know. You can write the story, address, details, about director, about company secretary, PAN, DIN, SIN, all that you will be able to remember. So that's no big point. But I have colored the keywords and given. I told 5 heads, 1 head is done. See the second head. Forms, procedures, and time for making an application. We already told within 30 days, but in what form? Form number FC1. Plus, you need an RBI approval under what act? SRMA and others also. Others means other approvals or the other regulations and all you will have to consider. So what I have done, I made a very simple point from this saying this. Read this, second point is over. Within 30 days with form FC1 along with the fees. Fees also is important. Without fees, how will you give? Fees also is important. RBI approval under SRMA Act. Attested copy should be given and any other approval if they ask, they should. To whom? ROC. Point number 2 is done. Point number 3. I told 5 points. No, point number 3. You should give it with a fees. You should ensure that the jurisdiction over the New Delhi, they should, that is the major thing, major place where you will try to have. If the foreign company ceases to have the place of business, that also give notice of the fact to the registrar, then inform him that there is no other place. And every fourth point, every foreign company existing at the commencement which has not delivered to the registrar will be obliged under the Companies Act 1956 as well if you have not done as per 2013. See what I am telling you. If not under the new Act 2013, you will be obliged as per the old Companies Act 1956. This is point number 4. Are we clear? Point number 5. Forms, procedures, alteration of documents if you do, that also you will have to intimate. If you would have studied the alteration of MOA, AOA, that similar thing here you will do within 30 days again to the registrar in form FC2. So what you will do now, you will stop the video, you will glance what I have done, or I will also show you again this 5 points bullets I wanted you to write. What is the first point bullet? First point bullet is what? Within 30 days, you will have to give all the details. Point number 1. Point number 2. 30 days like FC1 you should give with the RBI's attested approval under SRMA plus other approvals. Point number 2. Point number 3. If you are ceasing to have a place of business, tell that there is no other place of business in India with a prescribed fees. Tell that also. Third, that means here we are going to talk about ceasing. Third point is ceasing. Second point is how, what is the manner of applying with the form FC1. 2 is done, 3 is done. If not under the fourth one is, if not under the new act, then as per the old act. Point number 4. This keywords type of writing will help you enormously. I hope you should have done for other chapters, because all the one-liners and all I have given, all the concepts I have given, from where that case will be given, all that we told. So we made it very, very strong and careful. 5th one, it is going to be any other alteration, you are going to do it in FC2. That is all that is going to be there for this 5 points, which you should be very, very, very careful. Are we clear? This 5 heads is going to be important. And story, electronic mode, but does not have a branch in India. How it is going to be? They are talking about this. Now read this point. Search and Find PT Limited, which is incorporated in Singapore. Okay. The company sells its goods through electronic mode. However, it does not have a branch or office in India. Is the company required to submit the documents? The answer is what? I don't bother whether it is going to be in a place of business in India, but if through an agent or electronic mode means, I should consider that as a foreign company. Place of business in India is important only. We are not saying, but branch or office is not there. But means through agent you are running, or through an electronic mode, or through physical, that is allowed. No, see the answer. Yes, you should submit the documents. Now, very easily they will deceive you saying, I don't have a branch or office in India. Why should I submit all this? The answer is, that and all is not the point. What section 2 subsection 42 told? Any company or body corporate incorporated outside India, A, place of business in India, whether by itself you have not done, but through an agent you can do no, or physical mode or electronic mode you can do no. And 2 points I told you, no, and condition. Conducts any business active in India in any other manner shall be considered. So you should do it. That's all, very simple. So don't get deceived on any branch or office in India is not there. That means then it is not foreign company. Don't deceive on that. You should understand that it can also be you or through your agent. Somehow activity is happening. No, simple point. Somehow activity is happening. Physical or electronic or you or agent or whatever it is happening. And you are ensuring that the business activity is happening. Yes. Place of business somehow with some other person is happening. Submit the document. You cannot escape from that obligation. Not necessary, it should always be you. It can be by any other person as well. Are we clear? Accounts of the foreign company. This also I told you it is important. Every foreign company in what year? Not financial year, but calendar year. Balance sheet, profit and loss account, all the particulars you should deliver, and deliver a copy of these documents to registrar. So you should not only maintain, you should also submit or deliver to ROC. Simple point. I'm going line by line because I don't want to miss out anything, though it's a very simple chapter. For small chapter itself, we have covered like this. Think about big chapter, how much we have covered. Line by line only we have covered. So ensure you are covering this. Always please understand or condition or and condition. Here it is all and condition. There is no or, either or a. Everything has to be complied. Okay. For this, schedule 3 has to be done. Schedule 3 another. You already know. Financial statements format of the Companies Act. Schedule 3 is as per Companies Act only. Correct? Some people even don't know from which schedule. Schedule 3 they are telling which act they don't know. So be very careful. How you will bother about documents? Books of accounts is as per what? Chapter number 9. AS 21. Consolidated financial statements also is important because the parent foreign company, that, this and all. Then the third one is you should know about the financial year. We know what is that financial year, 1st April to 31st March. That story and all will be there. And the most important keyword here is you can apply the central government on saying that allow any period as my financial year, whether or not that period is a year. That means foreign company is having some other year. You can ask the central government because foreign company incorporated outside India, but place of business in India, no. So you can apply to central government and say, sir, they are considering that as their accounting period as a financial year. So you also give me that period itself as the financial year, so that I will have no problem. To whom you should apply? Apply it to central government. Because that fellow will follow something, you will follow something which will be very tough. You cannot apply ROC because above that central government is there. Apply to central government, ensuring that, sir, please allow that period, any period as its financial year, so that I will do this. They are asking this in the question and answer. Can you change the financial year by application to someone? Yes. If you apply to central government, if they allow any period, they can consider that as a financial year. Not necessary. It should be 1st April to 31st March. You can go as per your foreign holding company. Are we clear? Yes. I wanted you to listen to this video one time or twice. You will be able to get this very, very easily. This is the story which they have already told. See here. One example they have given. ROK Limited is a company incorporated outside India, having place of business in India. ROK is a subsidiary of HOK. Okay, HOK Limited holding company registered in Australia and is required to consolidate accounts with HOK. So ROK also is a company outside India, and that's a subsidiary where it is incorporated outside India in Australia. So they wanted to consolidate with the HOK. HOK is your holding. So holding, H is holding. Accordingly, if HOK Limited is required to follow financial year, which is other than 31st day of the March every year, which is in place of business in India, which is in India, ROK can make an application to central government to follow the financial year as per HOK Limited. Because in Australia, it is different, but it's a foreign company. So they should apply to central government to follow the financial as per the holding company. So subsidiary company will apply central government to follow financial year as per holding company. That's all. Write this and keep. That's all. This, based on this, they will ask one question. I'm only telling you chunk type of question, so you should be able to get it. Are we clear? So subsidiary company can go as per holding company. This is what I told in very simple words. Are we clear? Any other central government will ensure that any other exception, any other modification, they will allow. If the documents are not in English, then I'll annex it in English as well, because English is primary. This is other conditions, other exceptions or modifications, that and all they will do. And for all the foreign company, you should inform that you should be doing it with the registrar as well. Financial statements is FC3. So write 1, 2, 3 separately. Forms FC1 means what? FC2 means what? FC3 means what? You can get it from the MCA website. You can get it from the study material. And this is for your financial statements. Hardly 1 or 2, 3 forms only in FC foreign company. It is going to be there. This is the 4th point. You will give it to the registrar. And according to the company's registration rules, if the company, foreign company ceases to have, that also you should inform to the registrar, which we already told. And the 5th point is very important. First 4 points you have written. So write this. Right? I wanted you to write this point. Write section 381, 5 points. What is the first point? Maintain and submit the documents to the registrar, the financial statements and all, along with as per schedule 3, as per chapter number 9, as per AS 21, as per the financial year. Central government, you will have to apply to the central government if you wanted any other period. So that is your point number 1. See how many points I'm telling you. I'll repeat again. Number 1, as per the calendar year, you will go as per the balance sheet and P&L, submit the documents to the registrar, as per schedule 3, as per chapter 9, as per AS 21, and apply central government if you wanted any other period as your financial year. Okay. This and all you will write. Then point number 2 is any other exceptions or modifications central government will give. Point number 3, if the documents are not in English, put it in English also. Point number 4, all the financial statements which we told as per the changes as per 381, the section previous, then you will have to submit it with the registrar in form of C3 financial statements and other forms. Point number 4 is done. Point number 5 is this. We will cover now point number 5. Every foreign company, along with the financial statements, what and all should be filed? Related party transaction. Where as per what? Section 128. Now that and all is not informed. I am telling you what is there in section 188, which is the related party, which is your AS 18 also. It is not there in the material, but you should connect. Repatriation of profits. Where will you study about this? In FEMA 1999. I am including that also so that it should be easy for you to cover. Transfer of funds, if there is anything, that statement also. So give all this to the registrar. When will you do all this? The exam question. When you will give all these documents shall be mandatorily delivered to the registrar within a period of 6 months of the close of the financial year. Within 6 months, you will have, once the financial year is closed, within 6 months you will have to, because it can be based on any financial year closing. Within 6 months of that, deliver it to the registrar. Frequently asked question, the 6 months, 330 days is one, 6 months is one. They will ask you in the exam. Note it down and keep. In book back also they have asked. In RTP, MTP also they will ask. So there is no doubt. Don't confuse that with this. This is overall documents that you will submit it with the registrar. That is one example as well. Book back question also is there. Everything 6 months, 6 months, 6 months of the close of the financial year. What are the 3 statements? RPT, related party transaction, repatriation, and transfer. So RRT is how you will remember. Remember this as a point. When we already told it before from the close of the financial year, any financial year, whichever they are going to give you 6 months is the time. 30 days we have already told before on the FC1. Are we clear? This only is the major. Now, audit of accounts of the foreign company, value addition point only. It is not a big point because audit of accounts means as per what? Audit and auditors, chapter number 10. Who will do this? CA in practice will try to do the accounting and auditing. Whatever the rules that they will say. See here, provisions of chapter number 10, audit and auditors shall apply mutandis mutandis. That means however it is going to be, same thing will be applicable to foreign company. So we covered all the other chapters connection references. Chapter 9, chapter 10, chapter 3, chapter 5, deposits, chapter 6, charges, all that we are covering. Chapter 4 is debenture. Yes, everything is getting connected. These 2 sections, which is very, 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 very crucial. So please take down these 5-6 points and make yourself very, very strong. So 381, here we talked about all the points that you will try to connect with this. So you should be very, very careful. FC2 and FC3, it should be very important. Are we clear? This only is your major provisions that you have in 380 and 381. So have you note down these points and all? Please note down these points. So now the other points in this chapter is display of the name of the foreign company. Where will you display? Outside of the every office, outside of the place where you are carrying. What and all you will give? Name of the company. Please write along with me so that it should be easy. Make it like keywords. Name of the company, name of the country. Will you do it in English? Yes. Will you do it in other languages? Yes. where also you will give other things, that in business letter, in bill heads, letterhead, letter paper, any notice, any official notification, all this you will give. Please write down this whenever I cover this class, so it should be very, very helpful for you. Okay, outside the place of business, the name of the company, name of the country in which you have incorporated the company, language, English and other languages, all the other places you will display. This is basic, which we already would have told in the previous chapters. If the liability of the company is limited, exclusively state it in the prospectus and the other places as well. Limited company or unlimited company you should do. So here they will say PTE limited and all, correct? So in the foreign company, if you see that word, so limited means inform that also. That's all is the section. So where and all you will have to do. Your name of the company, name of the country, where and all. Everywhere, business letters, bill heads, letter paper, that's also this point is going to be major and crucial. So 3 points I told you, no, in that particular. So one, it is the places. One, whether it is limited means you should do. And another is the name of the company, name of the country, everything you will have to. Name, place, and liability. That's all these 3 points, name, place, and liability. Remember this 3. Name, place, and liability. That's all is this particular section. Service of foreign company. What mode I already told you. It is post or electronic mode. Electronic mode I told you very important. Correct? Next. See the section numbers like this. It will cover. Debenture, annual return, registration of charge, books of accounts, inspection. We already told. Debenture means 71. Provisions of annual return means 92. Remaining stories and all is nothing. We already covered in that particular. Then annual return. Here they will ask you FC4. Mark it important. FC1, FC2, FC3, FC4 is this. Annual return is normally how many days? 60 days. Be very careful. 30 days count we told. 6 months count we told. 60 days for annual return. Remember all these 3 headlines. The numbers. Within 60 days from the date or last date of the financial year, file the annual return. Where you will study this 92 to 94, you would have studied the same thing here also, but form is FC4. So I will again repeat, 30 days different, 60 days different, 6 months different. As per 128 means books of accounts you will have to maintain. We already covered in chapter 9. Chapter 6, registration of charges will apply. Chapter 14, inspection, inquiry, investigation. If there is any investigation or inquiry, inspection, yes, as per chapter 14, they will do, which we already told in this. If you remember, see this. We have already showed 4, 6, 7, 9, 14 and all we have already told. Okay, that's all is this. Fees, as per what fees? Registration of the foreign company rules 2014 fees will be charged. Okay, that's all is this particular section. I told you, no, it's very simple. Interpretation. They will check whether who is a certified copy, what is a certified copy, who is a director, who is a place of business. All this and all is based on what? Is based on definition of foreign company. Where did we study? We already studied what is section 2, subsection 42. So if you glance the illustration, you will understand what is place of business. Place of business means what? I already told. How many times I'll tell you? Incorporated outside India, place of business in India, and you or through your agent or through electronic mode or physical mode or whatever, you will ensure this. Place of business is your share transfer place or registration of office. This is POB. So add this point also with section this, which we already told interpretation has to be connected with definition we covered. That's all. Business activity of any nature in India, yes, it has to be considered. Yes. Next, dating of prospectus and particulars to be contained. What did I say? Go and study section 26. I am not going to discuss this because I have colored the keywords. You will be able to see this, but I don't need to discuss because I've already discussed too many times in chapter number 3. You can go and connect with that. Whether you are issuing or circulating or distributing, it should be dated, it should be signed. Important. We already covered that. In any instrument or any provisions, date, place of business, everything, but ensure, provided, this point is very important, provided 1, 2, and 3 above shall not apply in the case of prospectus issued more than 2 years after the date. Sir, can I issue a prospectus after 2 years from the date on which we have commenced? You can do. It is allowed. After 2 years of commencement also, you can issue prospectus. Allowed, no problem. But 1, 2, 3 points will not be applicable. What is 1, 2, 3? Instrument, the instrument containing this enactment of provision address in India, you will not bother. That's what they are saying. Okay, that is, you cannot define this because after 2 years, the instrument or any enactment or anything could have changed. Address can be changed. Enactment could have been changed. Any provision could have been amended. Instrument could have been changed. How will you know? So you don't need to bother about that. Remaining will be done. It is allowed, but 1, 2, 3 alone will not apply. For that one example, they would have given. Glance this, very simple it will be asked in the case-based question. Simple, it is a second standard question. So I'm not reading this. Same point. 2 years you can allow, you can issue after 2 years also, but point 1, 2, 3 will not apply. That's all, same point. They would have told in example also. Waiver. Anything that you try to do a waive in the complaints of prospectus is not allowed. It is void. You cannot waive anything as per the prospectus. They say it is not enforceable in the court of law. You cannot waive because prospectus is a very important document. Form of application, yes, it is as per chapter number 22. Our chapter, same chapter. Exception, if you are in a bona fide invitation, bona fide means what? Good faith. If you have done it in good faith, you can try to do it in any other form of application. Even if it is not as per chapter number 22, it is allowed. For what it is not, all this and all is applicable. For here, it is saying not applicable, not applicable. What is that not applicable? It shall not apply to the issue of existing members or debenture holders of prospectus because we have already done it. Correct? Existing holders, existing members, debenture holders don't give. Second, issue of prospectus, it should be already dated, and it is already dated means don't worry about it. If it is dated, you will not bother about the other securities to be done because you would have already given it to the recognized stock exchange. This is not a big point. Remember this. Already, if you have given, you are not giving it again. That's all is the point. That is all is the point. Next, where you will not apply, same point. Whatever I told there, same thing they have repeated. Nothing else. Nothing else. Same point. Not applicable for uniform securities. That means if the same form of securities is given again and again, you don't need to issue every time the prospectus for a listed in the recognized stock exchange. It is not. Otherwise, very simple. Already existing member, debenture holder, uniform security, already have got the consent. Don't do it again and again. That's what 387 says. What is 387? Dating of prospectus and particulars. Don't give again and again same particulars. That's what they are saying. Are you clear? Nothing will limit or diminish any liability if you do it properly as per law. That's what they are saying. Expert statement. Again, go to the prospectus chapter and read about this thing. Experts consent and allotment relating same mutatis mutandis will apply to foreign company as well. So there is nothing I am going to discuss because hardly 2 points only. You can glance this. Registration of prospectus, very, very, very important. I have already told you, see the sheet. What and all was covered. Documents important, accounts important because so many connections will be given. Registration of prospectus important. Remaining and all, I will go it in like this because we have already covered. Registration of prospectus is very important. What is there in this registration of prospectus? We will cover now. What is there in this registration of prospectus? As already we told about the content of the prospectus as per section 26 expert statement, same point they will say, but they will also add some more points saying no person shall issue, circulate or distribute in India any prospectus offering for subscription in securities of a company incorporated inside India or outside India. Majorly outside India only they'll talk about whether the company has or has not established, or when found will or will not establish, unless before the issue, circulation or distribution. That means only after prospectus you will give all the other details. That's all. So they will say the place of business in India unless before the issue, circulation or distribution. So issue first the prospectus, circulate the prospectus, distribute the prospectus, then only the other details. What are the other details? A copy certified by the chairperson of the company plus 2 other directors with a resolution, and then give it to ROC. So resolution you should pass. What is resolution? Motion resolution we would have studied in chapter number 7. So I told you what is that resolution. That you will submit it to ROC. Then the prospectus. Then whatever is endorsed and attached as per section 388 on the other expert statements. Apart from all this, you will also annex some documents. These previous points are normal. Normally, you will have to get it certified. So this is going to be the first point, certification, then delivery, then endorsing. Please take down this point. This section number only, I wanted you to do fully because I told you what is important for this particular chapter. Okay, because remaining and all is connection. What and all you will annex? Any consent to the issue you will annex. Any contract. So see what I'm doing. Any consent, any contract of the appointment of managing director or manager, you will do it. But it should be ensuring that everything should have a full particular. Any other material contracts not entered in the ordinary course, unusual course of business. If you do it anything within 2 years, you will give it. Normal means you don't need to give. But something is unusual means, don't you think you should give it in the prospectus? Yes, because it has to be important for the ROC. Underwriting agreement, if there is anything. POA, power of attorney. That means I am giving power to some other person to act. Agency, principal agent relationship. A principal will give the power to the other person, to the agent, so that he can act on behalf of the principal. Then underwriting agreement. These 5 points you should remember. Certification, resolution, whatever you deliver, whatever you endorse, whatever you attach, you will give it along with the consent, contract, you will give. Any other ordinary course of business, anything that you do within the 2 years, you will have to do. Underwriting agreement, you will have to do. Power of attorney, you will have to do. These 5 points is very crucial. These 5 documents, you will have to annex it along with the prospectus. Why I did not touch too much on prospectus? Because I told mutandis, it will apply as per the chapter number 3. Extra what you should annex, that only you should remember, no. So don't say in the exam as per 26 it should be there and these 5 documents. Till what is there in year 26. It should be dated, it should be signed. Based on that only expert statement, all that and all you cover, and then 5 annexures you will have to write. Are we clear? So this is going to be the 5 important annexures. IDR, I already told you what is IDR, what is going to be covered in IDR. All this we said, and most importantly for IDR, the central government will make rules. The IDR is the meaning that we have already told. Any depository receipt created by the domestic depository in India by a company or incorporated outside India. Very simple. Foreign company, what he will do? He will be incorporated outside India, place of business in India. So domestic depository receipt will be in India. That's all. By a domestic depository. Here one person will be there, but will be authorized by a company outside India. So that's, it is happening in India. So it is Indian depository receipt. That's all. So what and all central government will make rules, offer, because India no, so central government only will do offer, requirement, manner, how it has to be dealt, manner of sale. All these 4 points, who will do? Central government will do. Just glance this, you will be able to help it. Remaining and all is not the point. And more importantly, we told it must comply with what? ICDR regulations. What is ICDR? Issue of Capital Disclosure Requirement Regulation. Issue of Capital Disclosure Requirement Regulation. When you are going to subscribe for the securities, you should go as per ICDR. That is more important. This is what they have told you. Okay, that's all. Then compromise, arrangement, amalgamation means go as per chapter number 15, which is told in section 234. You have not studied it, but understand one thing: mergers and amalgamation. Mergers and acquisition, amalgamation with the foreign company. You are not going to read 234 now, but you will read it when you are going for self-paced module. Okay, so this is going to be the point. That's all. Remaining and all, you will have to obviously, if you go mergers and amalgamations, you will have to get a prior approval of RBI. Nothing else. You know why I am taking all this in a quick way? Because you don't need to sit and meddle with it. Only keywords, wherever I am writing, you write in the notebook, study for half an hour. I think it should be more than enough. See, when it's a chapter like chapter 2, chapter 4, chapter 7, chapter 9, chapter 10, FEMA, all this and all is going to be crucial. So for a chapter like small chapters and all, don't sit and meddle too much. Okay. So, but what is important, we are covering. Chapter section 34 to 36 will be applied. What is 34, 35, 36? I already told you. Civil liability, criminal liability, and punishment for fraud, which is as per PAS, Prospectus and Allotment of Securities. So, chapter number 20 will also be covered. Are we clear? We already covered this in chart in Prospectus, which I already told you. Punishment for foreign company. What is the punishment? 1 lakh to 3 lakh plus 50K per day till the default. And for officer in default, we call it as OID. What is OID? Officer in default, 25,000 to 5 lakhs. This I told you, they have asked in a book back question. So you can remember this. 1 lakh to 3 lakh for or plus 50,000 per day till you continue. So they will not stop with 3 lakhs as a maximum. Till the default continues, they will daily get 50,000, which is an enormous amount. Correct? So this is going to be there. Why? When there is a contravention of the provisions of chapter 22, you will cover this. That's all will be the story. Company's failure to, I told you what, just because they did not comply with the provision, it will not affect the validity of the contract. But the point is, if you have not complied with the provision, you cannot bring any suit. You cannot file a case. You cannot claim any set-off. You cannot do any counter claim. That means if somebody is claiming, you cannot do a counter claim. You cannot institute a legal proceeding. See what I have told. Here I have given a tick. That means what? It will not affect the validity. Here I have told into. That means what? Certain things you cannot do. What and all you cannot do. So write it separately. You cannot bring any suit. You cannot file a case. You cannot claim a set-off. That means you are giving 10,000. He should give 5,000 means that set-off you cannot do. Counter claim, whatever the claim that you are going to give against that particular previous claim, you cannot do. No legal proceeding you can institute. Unless you complied with the provision, you cannot do all this. But it will not affect the validity of the contract. It will be valid. But you cannot do if there is a case filed. You cannot enforce it in the court of law. For you, it will not be valid. For that fellow, it will be valid. Okay, that is what they are talking about. Rule number 12. If there is any action for improper use, for description, improper use of a foreign company or description of the foreign company, you will have to be investigated as per chapter number 14, section number 210. What is chapter number 14? I told you 3I. Inquiry, inspection, and investigation. That is called 3I. That's how I will make you remember. Investigation. So can you investigate if there is any problem? Yes. As per section 210. That's what we are told here. That's all. Exemption. Who can give exemption? Central government can give exemption. Generally, who will be exempt? IFSC will be exempt as per SEZ, which we already know. That is all there for this particular chapter. Now, go again from top one. Listen to this video again. Fully. First, get the flow. Second, write the keywords and glance. 2-3 times you watch the video with the keywords underlined. When you underline the keywords and write, it should be easy. Don't read only from the material. Anyways, for people who have got this recorded classes, I will share this PDF also. So there is nothing to write for you. So what I have done, listen to this video 2-3 times, enough. After that, you will not even touch this chapter. This is going to be enough. Now, summary you can glance. Multiple choice question. 30 days count. I told you which is important. Yes. Then what? The punishment I told you it is important. They have asked this question. Then what if there is no place of business in India? It's not a foreign company. That is one point. Fourth, who and all will be liable for this? All the directors and company secretary for that one pointer. And then within 6 months of the close of the financial year, you should give the documents which I told you. I told you 30 days, 60 days, 6 months, all this and all. Descriptive question is based on what? Is based, if you see this, it will all be based on what? Section 2, subsection 42, 380, 381, and 389. That means documents, accounts, and registration. That only will be majorly asked. Are we clear? This is what is there in this particular chapter. You can glance this. What I told only will be there. It will not have beyond this as an effect. See, I've colored and studied already what is being there. 380, they will ask you. Section 2, subsection 42, they will ask you. 380, again, they are asking. Full particulars. 381, they are asking. Registration, they are asking. Section 2, subsection 42, again, they are asking. 389, registration, that connection they are asking. 380, again they are asking. That's all. That is all for this particular chapter. I hope you have got this fantastic understanding of this, like the other chapters as well. So whatever I told in this video, do it. It should be really, really good. I hope this should have been done. So we are done with this Companies Act also. Thank you. Have a good day.